object of Article 30 is not to, if I may use the expression and don't take it otherwise, is not to ghettoize the minority. That alter the...
No. I can challenge it, Madas. Kindly, that's the point. Established or incorporated by or under a central law, a provincial law, or a state act, or an institution deemed to be a university under Section 3, or an institution specially empowered by an act of Parliament to confer or grant degrees. So, Madas, as a matter of law, I can't get a degree. I can't be called a university unless I'm incorporated under the Central Act. Now, Madas. Now, where does this provision come from?
Mr. Sibal,
Yes.
please refer to section 23.
Yes,
In
that
this
was
case, the proviso will apply.
Yes.
And 22 may not apply.
No institution, whether a corporate body or not other than a university established or incorporated by or under the Central Act or a provincial or a state act shall be entitled to have the word university associated with it, provided that nothing in this section shall for a period of 2 years from the commencement of this act apply to an institution which immediately before such commencement had the word university associated with its name.
So what happens is, in this case, because it was already a university
Correct.
by a Central Act, is the proviso which will come into play.
Correct.
And for a period of 2 years, there was hiatus.
Correct.
They could then apply and confirm, or the UGC
Correct.
will confirm their status as a university.
Correct.
And accordingly it will proceed. In this case, because it's more than that, because they were already included in the
Right.
7th schedule entry 63.
Yeah. But I'm not in that
22,
context.
22 and 23 occupy different fields.
Yes.
22 deals with the right to confer a degree.
Yes.
23 deals with the use of the expression university as part of your name.
Absolutely. I pointed out 23, my lord pointed out 22. But Malas, I have a different argument to make. What my lord is saying is absolutely right. But my argument is, where does 22, 23 come from?
Just read 22(1) again. Once
Very
again.
well. The right of conferring or granting degrees shall be exercised only by a university established by or incorporated by or under a central act, a provincial act, a state act, or an institution deemed to be a university under Section 3 of the of an institution specially empowered by an act of Parliament to confer or grant degrees. The question that your lordship should ask yourself is, where does this come from? Where is this provision? What's the origin of this provision? And the answer is 1906.
Institution which is not established or incorporated by or under a central act, provincial act, or state act. The substantive part of 23 says you cannot use the expression university as part of your appendix.
Correct.
The proviso, however, contemplated that there may have been universities earlier
Yes.
which were using the expression university,
Yes.
though they were not covered. They were not.
So you are given 2 years.
You are given. It's a sunset clause.
Absolutely.
You are given 2 years to bring yourself in conformity with the UGC Act.
Absolutely.
This case, AMU is not within the proviso for this reason. AMU had already been constituted under an act of the then Dominion legislature, and which law continued in force after the Constitution under Article 372 of the Constitution.
Exactly.
Those laws all continued post-independence.
Yes.
So it continued to be a statutory university. As a university governed by 23, it had the right to award degrees.
Yes.
That's how they acquire the right.
Right.
But your argument is, without this, they wouldn't have had the opportunity to award degrees. Then you would have had to go back to Allahabad University or some other university as it was before the 1920s.
Absolutely. I'm deeply obliged to your lordships. But Manas, the point really is, and this is a different point, and this really tells your lordships the interrelationship between 1906 and 30. Where does this come from, regulation come from? It comes from 1906.
Referable to 1906 is also implicit in 30, because 30, our court has said, 30, though absolute, cannot preclude the Parliament or the state legislature, as the case may be, from making regulations which facilitate the character of the
That's under
institution
1906, Manas.
as an institution of excellence.
But Manas, that's under 1906. TMFI says that also. That regulation is under 1906. That's why, Manas, the absolute right is there, but the absolute right has to be regulated by standards.
Yes.
The absolute right is of the choice.
If you apply the expression administer in a very strict sense, namely that there should be no outsider at all, or exclude you on the ground that, look, there are only 37 out of 180. A minority can never run a university.
No, Malaj, in fact, it is contrary to judgments laid down by this court. Because this court has said that you can have whatever secular education it
One very important circumstance, you can't read Article 13.
outside.
Outsiders,
That's
not
correct.
minorities.
No, sprinkling of outside.
Outside.
Yeah, so therefore you could have outsiders, you will not destroy your minority status.
The
That's
object of
the
Article
point.
30, object of Article 30 is not to, if I may use the expression and don't take it otherwise, is not to ghettoize the minorities.
Yes.
So that, you get other people also associated in the administration, it doesn't detract from your character as
That's
a
the
minority.
point.
It's fair to be considered. Is that by the statute itself, you have to induct into your court a large number of people who are not minorities. This is as a matter of statutory interdict.
That's all right. But I can challenge it. Malaj, let's put it this way.
Does that alter the?
No, I can challenge it, Malaj. Kindly, that's the point that I made yesterday. If the statute interferes to the extent that I feel that my right to administration, which is the right conferred under 30, is being impeded, I can challenge it. But I can accept it. So the statute, and Malaj, we are not here dealing with the administration. This, Malaj, please appreciate, Basha never dealt with administration. Basha said, I have come to the conclusion that you are not established. The minority has not established this institute, and therefore you can't administer.
Basha went on the establishment.
So you don't have to go into that, Malaj. We really don't have to deal. The problem arose that in Basha was, the council argued that assume that I am not established as a minority institution because the administration is over.
Use establish and administer disjunctively.
That was
the argument.
That was rejected in Basha. That was rejected in
Which
Basha.
is that Article 30 does not mandate that administration must be only by the minority itself.
That's
In
correct.
the sense that the personnel who administer are not required by Article 30 to belong to the minority itself.
Exactly.
What Article 30 contemplates and recognizes is the right, namely the right of choice, the discretion which is given to the minority to administer
That's correct.
in a manner which they deem appropriate.
Correct.
Therefore, it's not that if you don't have only people of your community,
Correct.
then you risk losing your minority character.
Correct.
Because the choice is yours. You may have persons belonging to your community, you may not have persons belonging to your community.
It's an institution of excellence. There's no doubt about it. But Basha says.
Only one interjection, Malaj, only one, something is missing, therefore. You have placed on record the proceedings of the Parliament, Lok Sabha, dated 3rd September 65
Yes.
and 6th.
Yeah.
There is one proceeding before that, that is 2nd September, the day prior,
Okay.
which I have quoted, my lord, in my written submission. According to me, is an important piece of, my lord, parliamentary debate, which is not on record. I am not, my lord, imputing any motives. That's all.
Well, your lordship notices Chagla says quite the opposite on the 3rd of September.
That's true, but we can't.
And he is the mover of the bill also. So what does it, how does it take the matter further? I was only indicating how the reference came about. Malaj. Contradictory opinions can't be the basis of a judgment of a court. That certainly is settled law now.
Right. You can't quote one part and not.
No, you're right. I'm not disputing that. I'm not disputing what you're saying. Justice Gogai's reference was 3 judges. So this objection that, it can't be referred, Malaj, is all.
And though Chief Justice Gogoi was sitting on the judicial side,
Yes.
as Chief Justice, his powers are
His
preserved by
powers are
Order
there,
6
Malaj.
Rule 1
Yes.
to constitute
And then
charge of
PM
judgment.
If bench consists of the Honorable Chief Justice, it can be.
Why can't 2 judges say refer it to 7 and refer the matter to the Chief Justice?
Anyway, but I'll not reduce the debate to that level.
But
I'm not going to
taken
raise that.
objection.
We have addressed your lordships on marriage. I will also.
Correct,
Lordships-
because initially he did, therefore I.
The matter is too important for us to really
Yeah,
rest the judgment.
exactly.
What I initially
So,
said
we
was,
can't be oblivious to the fact, reference of 1981,
certainly,
tagged on to 11 judges,
certainly. But I'm-
left open in PMA 5.
Yeah.
Then noticed in Justice Gogoi in the referring order of 2019, the 1951
Yes.
and the 65 amendment,
Yes.
right?
Yes.
The Allahabad High Court sets aside the 1981 amendment
Yes.
on the ground of Basha.
That's correct.
Now, two questions will arise before us. Suppose we hold that we accept your, for the testing the argument.
Yeah,
Suppose we accept your argument and hold that Basha was wrongly decided.
right,
Basha upheld the 1951 and 1965 amendment.
correct.
What would be the consequence of our coming to the conclusion that Basha was wrongly decided on the amendments which were in challenge in Basha? Second, if we hold that Basha was wrongly decided, then what would be the impact of that on the Allahabad judgment? The Allahabad judgment dealt with a challenge to the subsequent amendment,
Yes,
right?
right,
Now, if Allahabad has relied exclusively on Basha,
right,
now if we come to the conclusion that Basha was wrongly decided,
correct,
it would immediately impact upon the judgment of the Allahabad High Court.
correct.
They are not severable.
Not in a
They are
reference.
not comfortable with that amendment.
No, no, we
defend
are
that
comfortable.
amendment.
In any case, my lord, but Basha
It's not referred.
will definitely have a bearing on the Allahabad High Court judgment, definitely have a bearing. Which
The
we have to
reference,
look at.
the reference has emanated from that 81.
So to say that that has a direct bearing.
The
Rather than
reference is in that
decides Basha, completely decides what the Allahabad High Court has decided, I don't know.
Not either.
No, not at all, because once Basha is declared to be in bad law,
Right,
the position as it was before Basha in law would have to be examined. That's
right.
it.
But as my
And
lord-
therefore, 81 amendment, the reasoning of the Allahabad High Court that the legislature is directly overruling the High Court no longer remains.
that is the second part. The first part is Allahabad High Court relies on Basha.
Actually, that's a place to.
Allahabad High Court directly relies on Basha to say what it says. And then in addition says that.
Mr. Kaul,
Has to overrule.
Mr. Kaul, Basha denies minority status to
Right,
AMU.
Right.
The 81 amendment sought to, as a solicitor, I'll put it in from your point of view, the 81 amendment sought to confer the minority status. They say that this was declaratory. We will have to decide that. Now, the fact of the matter is that if we come to the conclusion that Basha was wrongly decided,
Right.
the immediate impact of that would be that the denial of minority status to AMU was wrong. We don't agree with the reasons on the basis of which Basha denied minority status to AMU.
Right.
In which case, the reason why my brother is putting that to is this. If we overrule Basha, then the only basis for setting aside the 1981 amendment was that Parliament has merely nullified the judgment in Basha without taking away its basis. If we come to the conclusion that Basha was wrongly decided, that ground of challenge with the Allahabad High Court ceases to have any relevance.
Exactly.
But it has a direct impact on the decision.
Undoubtedly, but
All that I said was.
the whole postulate of the Allahabad judgment
Yes.
is that Parliament could not have, without taking away the basis of Basha,
Yeah.
overruled it by a simple declaration that they did by amending the definition.
Right,
But if we go to the source, which is Basha,
right,
and come to the conclusion that Basha was wrongly decided,
right.
the basis of the Allahabad judgment itself is taken away.
We are not concerned directly with 2006 or 2010 Act. That's not the subject matter of Basha, one. Number two, that has not been examined by any 2 judges bench or 3 judges bench.
I follow, my lords, but then in the reference
That's
order.
it, that's it. Now, it's directly making a reference over here without there being a direct, yes, what does the second order does of Justice Gogoi,
Yes,
Chief
yes,
Justice
that
Gogoi
refers
does
to it.
is, it just narrates the history, what has happened. The questions which are there are the ones which were already.
No, not necessarily. With respect, my lords, it will have some bearing. Why Justice Gogoi refers to it, and that is why we started by saying the scope of reference is concerned in our own terms. The entire reference, including Justice Gogoi's order, was about conjunctive or disjunctive. Yash